Hi, my name is Neil Dornbaum. I'm a partner in Dornbaum in Paraguay. Our practice is limited to immigration and nationality matters. What I'd like to talk to you a little bit about today is what happens in a termination setting. A lot will depend on whether you're in temporary status or you're pursuing permanent resident status. In most instances, if you're in a temporary status and you lose your job, you're only going to have three options available to you. The first is to leave the United States, and in most instances there are either none or very limited numbers of periods of time in which you can remain in the United States after the date of termination. Two, you can seek a change of status to a different classification. In most instances, if you're in a work authorized category, you may need to change to a visitor status to be able to remain in the United States. Or third, if you have advance notice of the possibility of losing your job, you may be able to extend your status with a new employer in the same category. If you're processing for permanent residence, you may have some additional options depending on where you are in the process. If you have an application for adjustment of status already filed and pending, then you may be in a position to continue to remain in the United States based on dependency of that application and may be able to continue your work and travel permission. You may also be able to continue that application under the provisions of the American Competitiveness in the 21st Century Act, what is commonly referred to as AC 21. Our office counsels both individuals and companies, and if you would like assistance in discussing what your options may be in a termination scenario, either for an employee or if you are the affected individual, we would ask that you please reach out to speak with an attorney in our office.